Yale University law student Robert Leider joins us to explain stand your ground laws. Robert, welcome.
Thank you.
Now, Robert, these laws are coming under intense debate because of the shooting of Trayvon Martin in Florida back in February, and they deal with a person's right to self-defense. But there are very few people out there who have actually explained what this law says about self-defense. So I thought I'd just ask you a very simple question to kick it off. What does the law say exactly?
So it's actually a very complicated question in part. There's a core set of requirements before anyone can plead self-defense when they use violence against themselves. And generally have to show that you reasonably believe that such force was necessary to protect yourself against the imminent and unlawful force by another. And in addition to those basic requirements, there's a whole set of additional requirements, one of which was the traditional English common law rule, in some cases, was a duty to retreat. So before using deadly force, you had a duty to retreat, and that was framed in a couple of different ways. In Florida, before the stand your ground law, it was that you had a duty to retreat if you could do so without increasing the danger to yourself. And the stand your ground law eliminated that requirement, and it created a whole set of presumptions that you reasonably feared for your life if your home was broken into, but that's not really involved in the Zimmerman and Trayvon Martin case.
Robert, in your view, was that a reasonable thing to do to get rid of the requirement to try to retreat, given that we live in an age of firearms and it's, I think, hard to know if your life is you're going to be able to retreat and save your life in doing so?
I don't think it's a reasonable or unreasonable distinction so much as it is the retreat requirement today often has very little application. So I think people exaggerate too much what the retreat requirement expected. In most places, the retreat requirement means nothing more than if you know you can retreat with complete safety and you're outside your home or fixed place of business, then you have a duty to retreat before resorting to deadly force. And in the age of firearms, it's often not the case that you know you can retreat with complete safety because you could always get shot in the back. And so the retreat requirement today often does not apply to a lot of standard self-defense cases. We're
talking to Robert Leider, a Yale law student who wrote an absolutely terrific op-ed today on the stand your ground laws. Robert, I just want to place the Florida debate in context. Do other states have these laws? And if so, how long have they been around?
I think at this point that a majority of U.S. states have laws. I don't have the exact number off the top of my head, but most commentators state that stand your ground is the majority rule. And the rule has been around since the 19th century. So as the United States expanded westward, the duty to retreat generally did not follow. What it was replaced with was called the true man doctrine, because true men don't retreat in the face of danger. So if you look at states like California, for example, they've always had stand your ground laws.
Okay, so there have been some changes on the duty to retreat or not. What about initiating the dispute? Say I'm in the street in a dark corner of, I don't know, the Upper West Side, and I see somebody coming and I think that they're threatening me, and I feel that I'm in danger. Can I initiate a dispute? Can I take out a gun and say, hey, back up, buddy, get away from me?
So most of these laws don't affect, except possibly in the home, the general triggering conditions of self-defense. So you still have to show, for example, before you use deadly force, that you believe that your life was in danger, imminently in danger, and that your belief was reasonable. And so if you're in a dark alley and somebody's approaching you and you're not sure what their intentions are, it may very well be the case that you can't use deadly force. But if they're approaching you and you see them with a weapon and they start threatening you, that's a very different set of circumstances.
So in the Trayvon Martin case then, given what you've described of the requirements of Florida stand your ground law, what do the prosecutors have to prove? Is there a moment, for example, when the 911 dispatcher said, don't follow him? Tie this together and explain to us what it means for this particular case.
So before 2005, the question would have been, could George Zimmerman retreat without increasing his danger? And one of the questions will be, when would that duty of retreat been triggered? And generally, the duty to retreat is triggered when you reasonably believe that you may need to use deadly force. So it may not, even assuming Mr. Zimmerman was tracking and pursuing Mr. Martin, and I know the facts of this particular case are being disputed by each side, the duty to retreat would not have come into effect unless and until Mr. Zimmerman felt that he was facing unlawful deadly force from Mr. Martin.